afterward. And so we are recording here. So hello, everybody, and welcome. My name is TJ Scott. I'm an estate planning attorney located in Bloomington, Minnesota. I'm the owner of the law office of Timothy J. Scott. And what does it mean to be an estate planning attorney? Well, it means that I help people to get their affairs in order. I help them to plan for what's going to happen after they're gone. How is their family going to be able to deal with things? How are they going to be able to deal with the assets and handle that? I also plan for incapacity. And so I help my clients to figure out if something were to happen to you tomorrow, if you were in an accident, how can you make sure that there's somebody who can make financial decisions for you, make healthcare decisions for you, that you have somebody in place to be able to do that? Those are the kinds of things that I work on. I know it's kind of a dark topic, but I also believe that knowledge is power. And I believe that having some knowledge about this will give you power to address it, power to confront it, and power to make sure that this isn't something that has to create fear, create anxiety in your life. It's something that you can have a lot of clarity about by getting answers. And I'm here tonight to provide those answers and to provide some really valuable information. And I also have some valuable offers that I'm going to be making at the end. So I hope that you'll stick with me here so that you can find out how you can get a custom tailored estate plan written for you in the most affordable way possible. But before we do that, I just want to say the best way to learn is to be here and be present with me tonight. You have set aside this hour of your evening, and I want to encourage you to turn off any distractions. If you have separate tabs open, if you have the TV on while you're listening to me, I encourage you to just set it all aside and give yourself this time. Give yourself this time to learn this information. It can be complex. There are a lot of moving parts, but I promise I'm going to break it down in the most simple way possible and give you the information as cleanly as I possibly can. I always say your future self is going to be glad that you took the time to sit and learn with me tonight. And again, if you stick around until the end, I do have some fantastic offers that I'm going to make. One of those is how you can get a free one-to-one session with me where we'll talk about all the things that you have and all of the people that you love and how you can plan for those things in order to make things as smooth and as simple as possible for the people that you love when you're gone. Plus, I'm going to give you a bonus gift that's going to make it even easier to get a custom tailored estate plan in place, but you've got to stick around until the end to find out how you can get that. I want to ask everybody here, I want to take a pulse of the room and find out, do you have an estate plan in place? And I have the ability here to pull up a poll, and hopefully you've seen that poll launch, and you can answer it yes or no. Do you have an estate plan in place? The things listed on here are parts of an estate plan. They are elements of an estate plan, and altogether they make up that plan. And so your estate plan includes things possibly like a trust, definitely a will. If you have minor kids, it needs to include guardianship nominations. Who's going to take care of those kids if you can no longer take care of them? A healthcare directive, who can make healthcare decisions for you and what kind of healthcare decisions can they make for you? A power of attorney, who can make financial decisions for you, including writing checks on your behalf if you can't do that yourself. And beneficiary designations, especially on retirement accounts and life insurance policies, we see those beneficiary designations. And I see a smattering of people who do have an estate plan in place and people who don't. It definitely seems like more people joining here tonight don't have an estate plan in place. And I just want to set your mind at ease. If you don't have an estate plan in place, that's okay. And you are in the right place tonight. And this is the best time to get that estate plan written and to get that estate plan done. So I just want to give you assurance there that you are in the right place and you're doing the right thing right now by coming to this webinar tonight and getting the information that I'm going to be sharing with you. And if you don't have an estate plan in place, I'm curious, why not? And maybe something on here resonates with you. In fact, even if you do have an estate plan in place, but something on here resonates with you, I hope that you'll let me know. Or if a couple things resonate with you, I hope that you'll let me know. Something like 69% of Americans don't have an estate plan in place. And there are all kinds of reasons for that to be the case. Maybe you are too busy. And I'm saying people say, yes, I'm too busy. I haven't been able to get this done. And that's okay. I get it. As a father of four, as somebody who has started their own business and is working on their own in a law firm, I understand that life today is really busy. But if that's the case for you, I just want to commend you on being here tonight, being with me, and getting this started, getting moving in the right direction. And I promise you, I can help make the next steps as simple and as easy as possible for you. Maybe you feel like you're too young. I'm actually not seeing anybody saying that they're too young, which is kind of surprising. I think, youth is certainly relative, and I've seen plenty of sprightly 60, 70, 80 and older individuals. But really, anyone over the age of 18 should have some building blocks of an estate plan in place at a minimum. And I recently helped a young family, and it was a young wife with minor daughters, and the husband had passed away, or the father had passed away, and he left something of kind of a mess for the mother of the children and those daughters to clean up after he was gone. But it doesn't have to be that way, and you can make sure that the people that you love are taken care of. It's never too early to start this process. And maybe it feels like it's too expensive. And I do see some people saying this feels like it's too expensive to take on. It feels like I need to have an estate, like a named estate, if I'm going to have an estate plan. Swimming in gold doubloons like Scrooge McDuck or something like that. But I just want to assure you, estate planning is more affordable now than it ever has been in history. There was a time that estate planning really was just for the wealthy. And you had to fill forms out in triplicate, and it was really complicated because if you made a single mistake, you had to go over and start all over again. But today, estate planning is accessible. We have word processors, and it's made it more approachable and more affordable than it ever has been before. And truly, estate planning is for everyone now. It doesn't matter where you are at. Estate planning is for everyone and is accessible to everyone. And I'll talk a little bit more about how we can make it accessible to you a little bit later in the presentation tonight. And maybe you're worried about jinxing yourself. I don't see anyone saying, yes, I'm worried about jinxing myself, and that's okay. But I know it can kind of sit in the back of our minds and make us nervous. And I just want to assure you that I have written hundreds of estate plans, and I've never seen a correlation between somebody getting their estate plan done and having something happen to them. I know it happens in the movies all the time, that it's on the last day before the police officer retires and rides off into the sunset, or whatever the case is, and that's when something happens. But like I say, I haven't seen that in real practice. That's a Hollywood thing. That's not a real thing. Thank you for sharing with me in the polls. By the way, if you have shared with me, I really appreciate seeing where people are coming from and sharing their information with me. So if you do have a plan in place, and it does seem like there are some people with a plan in place, or again, if something on here resonates with you, I hope that you'll share with me in this next poll about what you want to learn tonight. Maybe you are considering doing an online will, or maybe you've already done an online will, and you want to know if it's okay and if it's going to take care of the people that you love in the way that you want them taken care of. Or maybe you did an estate plan, but it was 10 years ago, and you named guardians for minor children who are no longer minors, and you want to know if they're going to have to go live with Aunt Edna if something happens with you, even though now they're 25 years old. Good news, they're not going to have to go live with Aunt Edna, okay? But maybe you want to get some clarity and find out, how often do I need to update my plan, and what should I be looking for to see whether or not it's outdated? I'll definitely be speaking to that tonight. Maybe you just want to have a better understanding of your plan. Maybe you worked with an attorney, and that attorney didn't really explain terms or documents or what they were doing and why they were doing it. Or maybe you're just approaching this for the first time, and you want to have a better understanding of estate planning, better understanding of the different glossary of terms that estate planners use, and what it all means and how it all fits together. And that's fantastic too. If you have a specific question, I hope that you'll share it with me either in the chat or in the Q&A. And I see here somebody asking, I want to understand how international assets can be brought into a trust in the US. And that's a fantastic question. It's a complicated question, and it really depends on a number of different things. Each country has a different treaty with the United States about how property is going to be dealt with and how property is going to be handled. Sometimes it makes more sense to have a trust or to have some sort of instrument in the originating country, and to have some affiliation with a trust in the United States with that original country instrument. So it is a complicated question. It's something that we should definitely talk about more, probably one-to-one. And so I'll encourage you, when I offer times a little bit later here, how we can connect and how we can talk about that specific question. I see somebody asking, can I write my own will and have that will be legal? And yes, here in Minnesota, here generally in America, yes, you can write your own will and you can make a legal will. We don't have something that's called holographic wills. A holographic will is a will that's in your own handwriting and that you've signed your name to and is therefore considered legal and valid and enforceable in the courts of Minnesota. We don't have that here in Minnesota. However, we do have ways that you can write a will and have it witnessed by two witnesses and make it a legal and enforceable document. I'll talk about the wisdom of doing that and some drawbacks to doing that here as I'm going through things tonight. But it is possible to write and execute your own will in the United States. I would just say it's probably not advisable, almost never advisable to write your own will. And I've seen some of these wills, I've helped probate some of these wills that individuals have tried to write on their own. And I can tell you, it can get very messy in court when an individual has tried to write their own will and has tried to do their own planning themselves. And unfortunately, things haven't gone exactly the way that they probably foresaw them going when they were writing that estate planning document. Again, thank you for sharing in the questions. And I want to assure you that you are in the right place here tonight. You're in the right place. If you've written an estate plan, you're in the right place if you haven't written an estate plan. You're in the right place if you have someone or something that you care about and that you want to protect. And you're in the right place if you've done an online will or a fill-in-the-blank will, or you're considering doing an online will or a fill-in-the-blank will, but you're not sure if it's going to work. And you're not sure if it's going to give your family the simplest and easiest time after you're gone. And you want to have some more information about that. And you're in the right place if you're nervous about how much this is going to cost. I completely understand that. I promise you, I am going to speak very clearly to that cost question and to the expense question as we progress here this evening, because I understand how important that is to address and how important that information is for everybody. The reality is that the estate plan isn't about you. And this is something that really occurred to my wife and I when we were updating our estate plan somewhat recently. It's not about us, it's about the people that we love and taking care of them and making sure that they are going to be in a good position after we're gone. So these are 3 of my 4 kids. From left to right here, it's Margaret, Ben, and Elizabeth. And it really occurred to my wife and I that that's who we were writing our estate plan for. It wasn't going to make us richer. It wasn't like starting a business or investing in property. It was a way to make sure that they were well cared for. And it was a way of us communicating our love to them in making sure that they were well cared for if we couldn't be the ones there to care for them. The reality is your loved ones are going to know whether you lived up to your promise to take care of it after you're gone. So what are we going to talk about tonight? Here are the things that we're going to talk about. We're going to talk about planning for incapacity. We're going to talk about who can make healthcare decisions for you and what kind of healthcare decisions could they make for you. We're going to talk about who can make financial decisions for you and what does that look like. And then we're going to talk about planning for when you pass away. We're going to talk about guardianship if people have minor kids. I'm going to pull up a kind of demographics question and see if there are people here with minor kids. It's a very important topic if somebody has young kids, but if not, if everybody just has grown kids or there are no kids here, no people with kids here, then we can spend a little bit less time talking about that element. But guardianship is very important if you have minor kids, making sure that that they're not going to Uncle Larry. I always say, you don't want Uncle Larry taking the kids, but if a court thinks that Uncle Larry would be the best person to take the kids, you risk that if you don't make a guardianship nomination during your lifetime. We're going to talk about probate, and that's a court case that happens after you've passed away. It's not obligatory. It's not a necessary thing. You can choose to plan to avoid probate for your family and avoid the time, cost, and public nature of probate. But there is some planning that you have to do in order to ensure that your estate is not going to have to go through that probate process. We're going to talk about estate taxes tonight. We're going to talk about unclaimed property in the Minnesota Department of Unclaimed Property and how things end up there. We're going to talk about intangible assets, things like your values and stories, and how you can make sure to share those with the next generation. I see somebody talking about, or somebody asking a question about a disabled adult child and legal guardianship, and that is that's a very real concern for a lot of us. If you have an adult child with special needs, or there's somebody who are going to have a guardian and somebody to oversee and make sure that decisions are made in their best interest during their lifetime, that's a real concern to a lot of people. And so I will try and talk a little bit about that and talk about how you can get that in place. If it's your child, you can make a nomination for who the guardian should be if you can't be that guardian. And there is a way to do that. It's permitted by the statutes. And so we'll talk a little bit. I probably won't go into it too much this evening because we have so much to cover and so much to talk about. But know that you can reach out to me, and I'm happy to share that information with you and happy to share how you can get that done. Another thing to think about, if you have an adult child that isn't able to care for themselves, especially if they're receiving some kind of government benefit, you want to make sure that any inheritance coming to them is held in something like a special needs trust or supplemental needs trust. That it can be very damaging to somebody who is on a government benefit to receive an inheritance, because it can knock them off of that government benefit. And once all of the money from their inheritance is spent, then they have to go through the process of reapplying and being reaccepted for that government benefit before everything can turn back on. And so it can create these kind of dead zones where they're not receiving the help that they need when they need to receive it. And in addition to that, their inheritance is going towards things like paying for their food and their living location that would otherwise be taken care of by the government and not being enjoyed by them, probably in the way that you want them to enjoy it. So it's really important to do some planning there and make sure that is well cared for. And I'm seeing mostly people with grown kids, but I am seeing some with young kids. And so we'll spend just a little bit of time talking about guardianship for minor children here tonight, but won't spend too much time on it. Before we get into covering those topics, I just want to share a little bit more about me and about my family, since we're going to be spending some time here together tonight. So this is my family. As I said before, we live in Bloomington, Minnesota. My wife's name is Tobin, and my kids are Ben, my 10-year-old, Elizabeth, all the way on the left here. She just turned 8 this week. My 5-year-old Margaret, and my 9-month-old baby Bridget. My family is my whole world. Spend a ton of time with them, and I absolutely love them. I graduated from the University of St. Thomas School of Law in 2012, near the top of my class. And the very next day after I commenced, my son, Ben, was born. After law school, I found a job with a small estate planning law firm, and we did some tax preparation work as well. And I love the clients that I was able to work with in that law firm. I love the type of work that I was doing in estate planning. But I didn't always feel like I was providing the level of value that my clients deserved. And so a little over 3 years after starting there, I ended up leaving the law firm. And this is actually a picture from my last day there. Someone has to graduate at the bottom of the class. Now, this was not something that was said about me, but this was something that my parents said about an extremely negative estate planning experience they had working with an attorney who planned my grandmother's estate. And I remember them saying this. I remember my mom saying, someone has to graduate at the bottom of the class. But I don't think that it was this attorney's skill or knowledge. I don't think it was their intellect that caused a negative estate planning experience. I think that they were planning under a faulty model. I call it planning for death. And I'm going to talk about that a little bit more. But first, let's talk about some aspects of estate planning here this evening. So I know not everyone has minor kids here, kids under the age of 18, but for those who do, this is extremely important. Talking about guardianship, talking about two aspects of guardianship for minor kids: short-term guardianship and long-term guardianship. And the way to think about short-term guardianship is you and your spouse are out on a date and something happens and you're not able to return home. What is going to happen with those kids? Well, if they're left with a babysitter and there's no plan in place, eventually the police are going to be called and the police are going to bring in Child Protective Services to have the kids stay with Child Protective Services for a time. And I can tell you, again, as a father of 4 minor kids, I don't want my kids to have to spend any time with Child Protective Services. And that's why I have developed a plan and put a plan in place to make sure that those kids are taken care of by family, by friends, by people who love my kids and will make sure that they're well cared for in the case that my wife and I don't come home some evening. Long-term guardianship, there is a plan out there for your kids. If you don't have a plan in place, if you haven't made a guardianship nomination, and the plan is that a judge is going to decide. And unfortunately, it's probably a plan that you're not going to like. I referenced this earlier. If the judge thinks that Uncle Larry is the best person to take your kids, then Uncle Larry is going to get the kids. Maybe he has a stable job and maybe he has a place to live. And maybe you know Uncle Larry is the last person that should have the kids. But if a judge decides that that's the right person and that's in the best interest of the kids, then that's what's going to happen. But you know your kids and you know what's best for them. You know where they're going to flourish and what is the ideal situation for them. And that's why it's so important to make sure that you make guardianship nominations so that your wishes and what's best for those kids is what governs, and not a judge trying to make a decision after the fact with limited information. Okay, that's the end of the guardianship portion. And now this really applies to everybody. How are the people that you love going to receive your assets after you're gone? If you don't have an estate plan in place, or if you've chosen to plan with a will alone, then there is an estate plan in place for you. There is a plan for your assets after you're gone. And that plan is a court process called probate. And probate, like I say, is a court process. It's a lawsuit that you file against yourself with your own money for the benefit of your creditors after you're gone. Few things to know about probate. Probate in Minnesota is slow. Probate takes a minimum of 6 months to get through. More often, it's taking something like 12 to 18 months. The courts are kind of overwhelmed. The number of people passing away and the size of the courts and the ability to process a number of cases has just caused things to get bogged down. So it's taking a long time to get the probates processed through the court system right now. Probate's also very costly. There's an estimate here in Minnesota that probate costs something like 3 to 6% of the gross value of your estate. So you can imagine if all that you have is a house that's worth $400,000, already your estimated probate cost is something between $12,000 and $24,000. And it's not really hard to understand why. Again, that's the gross value. That's not the equity that you have in the house, but that's just a fair market value house worth $400,000. The probate's probably going to cost your estate something like $12,000 to $24,000. And like I say, it's not hard to imagine why. There are lots of fees and different things that enter into it. There are attorneys' fees and executors' fees, appraisers' fees, bond premiums, filing fees with the courts, creditors take a portion. In addition to all that, there are running costs. There are running costs on the house. There are running costs for utilities and for real estate taxes. The mortgage still needs to be paid during that time while you're trying to go through the process and get everything ready for sale. So you can imagine how everything can add up and how expensive it can get to get through the probate process when really that money needs to be available and needs to be doing work for the people that you love, the people that you want to inherit. We'll have a chance to look at and calculate your probate estate here in just a minute as well. But before we do that, I want to talk about the public nature of probate. And this is kind of unnerving, but right here I have the last will of Anna Nicole Smith. And the reason that I'm able to access this is because wills are totally public, and having a will, again, doesn't avoid probate. In fact, we have this terribly nerdy saying in the estate planning world Where there's a will, there's a probate. And I cringe every time that I say it, but I still say it because it sticks in your mind, and it makes you, it brings back the importance of making sure that you plan beyond a will. Where there's a will, there's a probate. Okay. And again, it's completely public. So you have to file the will. You have to file who the heirs are and who the devisees are. That's who is going to receive under a will. You have to file inventories of your assets, all of the assets that you have at your death. You have to file final distribution plans, exactly who is going to receive what assets from your estate. And again, all of this gets filed publicly. Here in Minnesota, you likely have heard that Prince passed away, and it's been years now, but things are finally starting to resolve in Prince's estate. And in fact, things are very close to being closed in Prince's estate. But you can go out there and find inventories of the assets that Prince had when he died. And you can go out there and find out exactly what each of his 6 half siblings is going to receive and how they're going to receive those assets, because all of that information is public when it goes through the court system. The court wants things to be transparent and public. You'll be able to find information on how much the estate is paying in estate taxes. Again, all of that information is out there, available and public, and you can go and find that information, as well as the millions of dollars that attorneys have charged in order to get that estate through the probate process. It is unnerving, again, to think that everything could be public. But again, probate is optional. It doesn't have to be public. If you don't have an estate plan in place, minor kids will receive assets at 18 and unprotected. And I know not everyone here has minor kids, but people who don't have minor kids, if you have grown kids and those kids have kids, if something happens to your child and a grandchild is going to receive, well, if you haven't done proper planning, that grandchild may be in line to receive before they turn 18 years old. And if that's the case, there's likely going to need to be a conservatorship, which is an extremely expensive court process with complicated annual filings that need to be made to the court and approved by the court. And that is a very expensive process that you don't need your family to go through. There are much simpler ways to permit your grandkids to receive in the case that something happens to one of your kids and they predecease you or they die at the same time as you. So I really encourage you to look into that and making sure that you are planning with that in mind. Okay, here's your chance to calculate your probate estate. And what I have listed here are some of the types of assets that typically go through probate. Things like real estate, so a family home or rental property, things that are personal property, things like furniture and household goods, jewelry, firearms, those typically go through probate. I also have automobiles listed here. Stocks, bonds, and bank accounts typically have to go through the probate process. And then business interests are also listed here. So these are the types of assets. If you have some of these types of assets, and it's unlikely that you have all of them, but if you have some of these types of assets, they would probably need to go through probate at your death. And you can get a very quick estimate for the cost of these things going through probate. Again, keeping in mind that here in Minnesota, probate costs something like 3 to 6% of the gross value of your estate. By adding up all of these amounts and getting 5% of that number by moving the comma over one place, so 850,000 is our starting number. You move the comma over one place to the left to get 85,000, and that's 10%. And then if you cut that number in half, so you cut 85,000 in half, you get 5% of the gross estate, which is within that 3 to 6% estimate that we have here in Minnesota. And so that's how I got this number. The estimated probate costs and fees for this estate would be something like $42,500. And in fact, this estate might even cost more than that because there are 2 parcels of real estate. There is a business interest, and all of those things cost a lot to continue to manage during the probate process when everything is frozen and you're not able to sell those assets or handle them in the way that you probably want to handle them. To add another wrinkle here, life insurance and retirement accounts are generally passed by beneficiary designation, and so generally don't have to go through the probate process. When something passes by beneficiary designation or by joint ownership, that happens by operation of law, and it doesn't have to go through the probate process. It just automatically transfers to that joint owner or to whoever that beneficiary is. However, if life insurance or retirement accounts are payable to a minor or somebody who can't take possession of that asset, somebody like a disabled adult with a legal guardian, then those assets would also have to go through the probate process, would have to go through a process like a conservatorship, and would be added to the cost of that probate estate. So you can see here, adding those assets, that life insurance and retirement account payable to a minor, significantly increases the cost of administering that probate. And again, totally unnecessary. You can avoid probate. And there really is a foolproof way of avoiding probate by using what's called a living trust. And I always like to do this demonstration about what a trust exactly is. A trust is when, the simplest version of a trust is when one person takes property and gives it to another person. And the original person who started with the property says, I'm giving you this property in order to hold on to it and follow these rules with it. And the person who accepted the property says, yes, I agree to deal with this property in exactly the way that you've told me to deal with it. That's a trust. This person who had the property originally is called the settlor. This person who's taking ownership and control of the property is called the trustee. And they have reached an agreement about how the property is going to be handled by the trustee. That it's the settlor's rules about how to handle the property. The trustee is just carrying out the settlor's rules in how to handle the property. Okay, that's the simplest version of a trust agreement. A living trust or a revocable trust or an inter vivos trust, these are all names kind of for the same thing, means that a settlor has given property generally to themselves as trustee, just wearing a different hat. And so they are the settlor, they're the trustee, they're also the beneficiary who gets to benefit from the way that these assets are handled by the trustee. Okay, so they are maintaining control because they're the trustee. They're also the person who funded the trust and wrote the rules about what's going to happen. But when they die and a successor trustee steps up into their shoes, that successor trustee is going to be able to read and follow the rules of the trust agreement in order to carry out what needs to happen to those assets now. And that really simplifies the process. I know it sounds a little bit complicated, but I can tell you, it very much simplifies the process compared to having to go through probate and going through that court process. But it's very important, as you've seen in my fancy little demonstration, that you make sure to give all of your assets over to the trustee. If you've forgotten to give something to your trustee, then that asset has to go through probate, and it's no good. You have to make sure that you fully fund your trust by giving everything over to the trustee. And what does that mean? What does fully funding your living trust mean? Well, it means different things for different types of assets. So for things like investment accounts where you're buying stocks and bonds or mutual funds, it means retitling that investment account in the name of your trust so that your trustee is immediately able to act on those investment accounts. For bank accounts, it means going to the bank and signing new signature cards there so that that bank account is no longer in your personal name, but now it's in the name of your trustee or in the name of your trust, that's who's handling that bank account now. For property, for real property, things like house, a cabin, hunting property, means executing deeds to transfer that real property into the name of the trust. For stock and bond certificates, if you actually have the paper stock and bond certificates, it generally means having those stocks and bonds reissued into the name of the trust instead of having them in your personal name. And so that often means sending them back with the information filled out on the back so that they get reissued in the name of the trust. For personal property, that's pretty simple to handle generally. It means assigning that personal property into your trust so that, again, it's been handed over to your trustee, and your trustee is the one able to exercise discretion as to that personal property. For life insurance and retirement account beneficiary, it means changing beneficiary designations so that it's going into the trust in the future. And I see somebody here is asking, won't your financial accounts with a bank just transfer to beneficiaries if it's set up with X beneficiaries as POD? And that's a great question. Oftentimes banks will permit you to set up beneficiaries or will permit you to set up what's called a pay on death or a transfer on death for the account so that it will, by operation of law, go to the beneficiaries that you named. The problem with that is that it requires a lot of forethought and planning, and it requires a lot of activity to go to each, if you need to make changes in the future, you have to go back to the bank and change all those beneficiary designations or change all those PODs. Whereas if you have it in a living trust, you can just make those changes in one place. For the beneficiaries in your living trust, it's much simpler. And so you're exactly right that there are ways to set up beneficiary designations or pay on death or transfer on death for certain things. Here in Minnesota, we even have where you can set up a transfer on death deed for real property so that it's going to somebody at your death. But it's complicated to plan beyond one person. And so if you have a plan where things are going to go to a child, if that child predeceases you, it throws everything into question. Those beneficiary designations become very complicated, and you're going to have to go and read the contract at your bank or go and read what the statutes say about what happens if a transfer on death recipient isn't able to receive, and where does it go at that point? And it becomes very complicated, but you can handle it very simply in a living trust to make sure that you're able to plan for, again, a very sad possibility, but something that there is a risk of happening in the future. So fantastic question. Yes, it's possible to set up beneficiaries or pay on death, and I have seen it work, but there are some serious risks to that if a beneficiary predeceases you. Great question. Okay, so we've talked about trust, and we talked about that living trust and how wonderful a tool it is in order to plan for your assets and to make things as simple as possible for the people that you love. Let's talk here a little bit about estate taxes. And I have here an old number on the screen, actually, that now that we are in 2023, the federal exemption amount is no longer 12.06 million. I believe now it is $12.92 million. And that means for your first $12.92 million in your estate when you die, you don't pay anything in federal estate taxes. Once you get above that, once you get to $13 million or $12.92 and $1, you do start paying estate tax, and you start paying estate tax at a pretty high rate, all the way up to 40%, so 40 cents on the dollar. It's very expensive. Federal estate tax is very expensive, but it applies to very few people. In fact, this is not the reason, estate taxes in general are not the reason that most people are doing estate planning right now. Estate planning generally is done to make things simple for the people that you love and to make sure that things are going to go smoothly for the people that you love after you're gone. But this may apply to you, and if it does, I want you to make sure that you talk to an estate planning attorney to start planning for it and to start making sure that you are able to only pay the estate tax that you need to pay. So there's a federal exemption where you don't start paying estate tax until you're above $12.92 million. And you actually get to double that if you're married. So it's, I can't do the math, but you can imagine it's something like $26 million that you don't have to pay any estate tax on, that you can pass free of any federal estate tax. Here in Minnesota, we also have an exemption. For your first $3 million, you can pass those assets without having to pay any estate tax. But once you get to your $3 million and first dollar, estate tax starts becoming due. And that's true whether you're married or not. So it's not double, it is doubleable, But in order to double that $3 million exemption, you have to do some planning at the death of the first spouse. And there are some things that you have to do, some things that you have to have in place in order to do that planning and make sure that you're able to double that $3 million exemption. On the federal level, it just doubles automatically. You get to use whatever wasn't used by the first spouse to die. In Minnesota, we're not that lucky that we have to use the exemption amount when the first person dies in order to get a second $3 million when the second person dies. So it's a little bit more complicated, but it is still possible to double that exemption. And again, here in Minnesota, estate tax Minnesota estate tax is generally not the reason that most people are doing estate planning. Most people are doing estate planning for other reasons, keeping things simple, making sure that things are going the way that they want them to. I see a question here. Me and my husband purchased a house 20 years ago. I was a stay-at-home mom then, so the house is not in my name. What do I do? That's a fantastic question. There are a number of ways to handle that. It's partially considered your husband's separate property, but spouses have an interest in the real property of their spouse. If something happened to your husband right now, you might not like the character of your interest in that property. It essentially boils down to a life estate for you, with the remainder automatically going to the kids. But that can complicate things like selling the house and buying another one, or selling the house and using the money to travel or do whatever you want. And so that might not be the way that you want things to go. We can talk about that. One thing that you could do is your husband could add you as a joint owner on the house. And if you were a joint tenant or a joint, if you had that joint tenancy with right of survivorship, then if your husband were to pass away, you as joint owner would be the complete owner of the property at that point. So that's one thing that you could do. Again, there's a transfer on death deed. That's another opportunity to plan and to get ahead of it in order to make sure that it is going to you and that it's not just a life estate that's going to you. Another thing that you could do is your husband could execute a trust, or you could execute together a joint trust and fund that house into the trust. And then you really have a lot of flexibility about how the house is handled and about how it goes to the surviving spouse, or if there isn't a surviving spouse, if your husband is the surviving spouse, how it goes to the next generation or the generation after that. You can build in a lot of flexibility in a lot of different ways, permutations about the way that that happens. So that's my recommendation, is to do some planning at this point and make sure that you are having that go in the way that you want it to go. All right. Will your assets be lost to the state? So does anyone have any idea how much money is currently in our State Department of Unclaimed Property? I'm not going to give you much time. In fact, it's already up on the screen. Over $700 million in the Minnesota Department of Unclaimed Property. Across the United States, that number is something like $58 billion in the different state departments of unclaimed property. And a big part of how the money gets there is that when somebody dies, their heirs, the people who come after them, their family and their friends, weren't aware of where all of the assets were. They didn't know all of the banks that grandma and granddad used. They didn't know all of the different real estate spread across the United States that maybe grandma and granddad owned. They didn't know the different retirement accounts or the different brokerage investment account that grandma and granddad or mom and dad might have had. And so something gets missed. And then over time, after a certain amount of time passes, that money or that property ends up with the State Department of Unclaimed Property. And it's something that you can search, and you can see, you can search your family members' names and see if there's property there in their name that you could go and collect on their behalf. But collecting that property is very complicated after somebody has passed away, and after, I believe it's 7 years have passed in order for it to get to the State Department of Unclaimed Property. And I can tell you, as somebody who is young and is still building their wealth and still building the estate that I want to have go to my 4 kids, I want everything to go to them. I don't want anything to be lost to the State Department of Unclaimed Property if it can be useful to them. I want to make sure that everything useful, every useful asset is going to them, or is going to help pay for their care after if something should happen and my wife and I were gone. And so this is something that I think is really important, but it's something that most estate planning attorneys don't talk about and don't cover. But it is something that I want to mention here is extremely important, I think. I see somebody asking, other than long-term care insurance, can assets be protected from long-term care costs? And that is a fantastic question. We have more ability to protect assets from long-term care costs here in Minnesota than we have in the past. There's something that has kind of been added through the court processes that other states have had for some time, called a medical assistance protection trust or a Medicaid asset protection trust, which is kind of a new planning technique that involves an irrevocable trust. I've been talking mostly about revocable living trusts, but there are some irrevocable trusts that you can also create. The thing with an irrevocable trust is you are giving up control. You're giving up your ability to affect that irrevocable trust in exchange for starting the 5-year clock and starting some protection on those assets. So the answer is yes, it is possible to protect assets from long-term care costs. And yes, it is good to start planning early in order to do that. And yes, there is even some planning that we can do as someone is going into the nursing home in order to protect some of the assets from those long-term care costs that are going to start coming due. But really, it's best to plan early, and it's something that you need to consult with an attorney in order to know your options and to start planning for those nursing home care, those long-term care costs. So I really encourage you to do that if that's something that's on your mind, that's a concern to you. Okay, this is something that's really cool. We've been talking about a trust. We've been talking about how a trust can handle your assets, hold your assets, and then after you're gone, your successor trustee can step up into your shoes and start administering that trust and distributing out that trust to the people that you love. Well, you can actually make your living trust a real treasure chest. You can build in protection into that living trust for things like a divorcing spouse or like a bankruptcy, so that the assets that are in that trust, that inheritance that you want to go to the people that you love, is protected from divorce, is protected from bankruptcy. It is very cool. It's very cool that you can build this in, this airtight asset protection. But again, this is something that you really have to work with an attorney in order to build it into your trust and to build it into your estate plan. Let's talk a little bit about planning for incapacity here. And the person that I have on the screen here is Terry Schiavo. Terry Schiavo was kind of a household name in about the mid-2000s when her case was going across the country's consciousness. Terry Schiavo suffered a cardiac event and was left in a vegetative state. And there was a disagreement between her husband and her parents about what should happen with Terry. Terry's husband thought that she should be taken off of life support and she should be permitted to die. She should be permitted to pass. Terry's parents were still holding out hope and wanted Terry to continue receiving that life-sustaining treatment, to be kept in that state, and they were hopeful that she was still exhibiting some signs of interacting with her surroundings and that there might be a miracle where she was able to pull through. There was a lot of conflict around this. There were a number of court cases all the way up to the Supreme Court of the United States. And it was eventually decided that Terry should be taken off of that life-sustaining treatment. And Terry did end up passing away. All of that conflict and all of that court wasn't necessary. Unfortunately, Terry didn't have her wishes down in a directive, in a healthcare directive, making it clear what she wanted in the case that she was in a vegetative state. If she was in that state where she wasn't clearly able to communicate her wishes and her desires. And so it left this room for interpretation and caused a lot of conflict, a lot of grief, and a lot of fighting in the family. But again, it didn't have to be that way. you can get a healthcare directive in place that makes it really clear what your wishes are and who has the authority to exercise your wishes on your behalf. And that's something that's very important. I know that's something that can be on a lot of our minds right now, but it's something that is very important to get done while you have capacity to do it. So we've talked about a lot of things tonight. We have talked about probate. We've talked about the time, cost, and public nature of probate. We've talked about guardianship for the kids, both short-term guardianship and long-term guardianship, and how important it is if you have minor kids to put those guardianship wishes into a document. We've also talked about if you have disabled children or children who have special needs and will need a guardian after you're gone, how important it is to have the guardianship recorded, the guardianship nomination in a document, and have that be made clear so that that is carried out after you're gone. We've talked about estate taxes a little bit. I know that doesn't apply to most people, and again, is not the reason that most people choose to do estate planning. But we've talked about unclaimed property and how real that is and how common a problem that is. Again, over $700 million in Minnesota, currently held by the Minnesota Department of Unclaimed Property. We've talked about asset protection and how you can build that into your plan. We've talked about planning for incapacity and how important that is. We've talked in particular about healthcare, but also financial. Having somebody who can write checks on your behalf is something that's also important to have in place. So with all of these things that we've talked about tonight, you're probably thinking, what can I do to do the right thing for my family? And what should it cost to plan right? And so let's walk through the options. And really, if something here resonated with you tonight, you have two options. You can either try to do it yourself, to create a plan on your own, or you can work with a lawyer. And keep in mind, not all lawyers are the same. So how should you choose? Is this something that you can do by yourself through an online will, something like that? Well, I like to frame it like this. You would probably benefit from working with a lawyer if you own more than just your personal belongings, things like cars, clothing, jewelry, furnishings. And there's kind of this number out there, $75,000. If your total assets include real estate or total more than $75,000, then you would probably benefit from working with an attorney. And if you want to ensure that the people that you love stay out of court and out of conflict, and that they have someone that they can turn to when something happens to you, then you need to work with an attorney in order to give them that counselor that they can turn to after you're gone. If you want a kids protection plan, which includes that short-term guardianship and long-term guardianship, or if you want to avoid probate or estate taxes, or if you want to protect your children's inheritance with that asset protection, then you have to work with a lawyer. Those are things that only a lawyer can do and only a lawyer can write into your plan. And if you want a guarantee that your plan is going to work when your family needs it to work, then you have to work with an attorney. And this is a story I like to tell here about a do-it-yourself project, because believe it or not, I am a big believer in general in do-it-yourself and in doing things myself. But one morning, I was going to take my son fishing, and we had ordered new fishing rods, and I was putting fishing line on those fishing rods because they came without any fishing line on the reels. And so I had bought some fishing line separate, and I was winding the fishing line on, and I thought that I had everything right. But when I went to clip the fishing line on one of the fishing poles, I still don't know what I screwed up. And I always ask, and maybe somebody can put in the chat if they know. All of a sudden, the fishing line started jumping off of the reel, and it was everywhere, and it was tangled, and it was a mess, and there was no way that I was recovering the fishing line that had jumped off of this reel, because it had knotted itself up, and it was terrible. It was unusable at this point. So that was a do-it-yourself project, but the situation, the results weren't that bad. I mean, they could have been a lot better, right? But I was still able to take my son fishing that morning. I just clipped the line, and maybe I lost, I don't know, 30 cents worth of fishing line, something like that. But I was able to see immediately that something had gone wrong. I was able to clip the line, bear some cost and move on, fix it, and get a working fishing pole and fishing line to take my son that morning. Estate planning is like the opposite of that entire situation. You aren't going to know if your estate plan is going to work for the people that you love until after you're gone. You're never going to know if it's going to work for the people that you love. It's for them to find out after you're gone. And it's not something that you can fix after you're gone. It's going to be up to them and up to the courts and up to lawyers and the whole probate process and different people making different arguments to try and fix your plan if something isn't right. And it's going to be expensive. It's not like that 30 cents worth of fishing line that I was able to just clip and move forward without. It is going to be expensive for the people that you love in order to try and fix that estate plan that isn't going to work or that might not work. And you're going to be left with this question: is this going to work when I need it to work? And that's not a question that you should have about something as important as taking care of your family and making sure that they are well cared for after you're gone and after they should just be able to focus on the process of grieving you. You really want to give them that space. You want to give them that space by having an assurance that the estate plan you put in place is going to take care of them and be the simplest estate plan possible for them to follow through and carry through on. And that's my pitch about why I think do-it-yourself estate planning is just probably is probably not going to work the way that you want it to work. And the costs are going to be borne by someone other than you. It's going to be borne by the people that you love after you're gone. One quick little note: if you want to give your assets to someone other than your kids, or if you want to exclude anyone who would normally receive, you really have to work with an attorney in order to make sure that you have carried out those wishes the way that you want to. So now you probably know if you are planning to do it yourself or if you would rather work with an attorney. But now, how do you know that you have chosen the right attorney? How do you find the right attorney? And I want to bring us back to this quote. Again, this was not said about me. Someone has to graduate at the bottom of the class. This was said about another estate planning attorney. And again, I think that they were working under a faulty model. I don't think it was this attorney's knowledge. I don't think it was their intellect, but I think that they were working under a faulty model. I call it planning for death. And this is what that typically looks like. This is the typical estate planning experience, is that you get form documents that are kind of set it and forget it. That you fill, the attorney is going to fill your name in a couple of places, and that's about all the customization that's going to happen. And you're going to set them in a desk drawer because it's not going to be clear exactly what they mean or what they say or what the different provisions actually do and mean, because that attorney chose them for you and didn't walk you through the process and make sure that you were the one choosing those provisions and make sure that you understood everything that was in that plan. Typical experience isn't going to keep your money out of the Minnesota Department of Unclaimed Property. It's just not something that most estate planning attorneys see as in their purview. And the typical experience may avoid probate, but it may not. And the sad fact is that it often benefits estate planning attorneys if they have to go to court and probate an estate plan that they wrote, because then they not only collect the money for writing the estate plan, but then they're also able to represent the personal representative or the family in getting that estate through the probate process. And it's a sad fact, but it's true. It's not something that I like to do or something that I want to do, to have to probate my estate planning clients' estates. It's just not. It's not something that should be done, and that's the kind of value that I think needs to be provided from a good estate plan, is actually avoiding probate. Typical experience probably isn't going to keep the family out of conflict. It's just, again, family dynamics, the workings of the family aren't something that most estate planning attorneys take into account. They're just very focused on your assets and maximizing the way that assets are transferred. Typical experience is only going to focus on the money, not your stories or your values, those types of intangible things that often are lost. It's going to leave assets to heirs unprotected without that asset protection that you can and oftentimes probably should build in to protect those assets from things like a divorcing spouse or a bankruptcy in the future. Typical experience is not going to have ongoing legal guidance. And the reason is that typically an estate planning attorney is going to charge hourly fees. There are going to be hourly fees accruing in the future when you pick up the phone and call them or shoot them an email with a simple question. And it's going to create a distance between you and the attorney and create difficulty in working with that attorney in the future. The typical experience typically doesn't adequately protect minor kids, especially that short-term guardianship is often missed by most estate planning attorneys. And it's going to leave you with this question: is this plan going to work when I need it to work? And that's never a question that you should have after you've worked with an estate planning attorney. Planning with me is a totally different experience, and I call it planning for life. Again, totally different. I charge flat fees, and I allow you to choose the fee based on some different packages that I offer. I want it to be a good fit for your family, not just doing what you want in your estate plan, but also to fit you financially and to make sure that it's something that's affordable and accessible for you. Planning with me means keeping your money out of the hands of the state. Again, that's something that's very important to me, is to make sure that all of my assets are documented and that the people coming after me are able to find and identify and collect all of those assets and get them to my kids where I want them to go. Planning with me means protecting your kids totally, both in the immediate and the long term with that kids protection plan. It also means keeping your family out of court and out of conflict. And really, that's at the heart of what I do as an estate planning attorney. What's driven me to be an estate planning attorney is, at heart, I am a peacemaker. And that's how I see myself. And that's what I want to do for families. I want to keep the peace for families. I want to keep families intact after they've lost that pivotal person, after they're grieving for that pivotal person, by making sure that they're at least able to avoid court and at least able to avoid conflict over the assets and over the things. Planning with me means knowing that you've made the right decisions, because I'm not going to make those decisions for you. We're going to walk through the decisions together, and I'm going to permit you to, with education from me and with information from me, I'm going to empower you to make those decisions for yourself, so that you understand them and so that you own that estate plan, because really you're the expert on your family and you're bringing that expertise to this, and you need to be making those decisions because you understand your family best. Working with me means protecting the family money from outsiders. Again, that asset protection that you can build in to make sure that your inheritance is going and is used by the people that you want to use it. And it means a lifetime of guidance and protection, because I'm not going to charge hourly fees after the fact when you need to pick up the phone and tell me, TJ, great news, my first grandchild was just born. Or TJ, great news, we just are planning on closing on that new property and it's our dream home. And we're so excited. We can't wait to move into this beautiful place. I want you to pick up the phone, and I want you to have that assurance that I'm going to be there on the other line, ready to pick up the phone and answer your questions, and not charging you for answering the phone and picking and answering those questions for you. If there are changes to your documents in the future, unfortunately, I can't roll those all into the initial estate planning fee, but we'll talk about that, and we'll talk about what a reasonable fee would be to make the changes. But I want you to have access to me. I want you to be able to pick up the phone and call me, or shoot me an email and get a response, and know that I'm working for you and working on your behalf. Planning with me means knowing that your plan is going to work when your family needs it to work. And really, think of it this way: it's a gift that you're giving to the people that you love the most. So what should this cost? And again, I completely understand that this is an area of concern for a lot of people, that cost is something that we are all sensitive to. And that's why I'm going to walk through this and talk through exactly what you can expect to pay for a typical estate plan from a typical estate planning attorney versus what you can plan to pay by using someone like me, who's going to give you a more comprehensive, a more careful and custom tailored plan that they will have walked you through. Keep in mind that this planning is going to save your family at least $12,000. That's 3% of a house worth $400,000. Keep in mind that probate, again, costs 3 to 6% of the gross probate estate value. So if all that you have is a house worth $400,000 already, this planning is going to save you at least $12,000, or is going to save your family at least $12,000. If you have assets in excess of $3 million, then this planning is going to save at least 13 cents on the dollar for every dollar in excess of 3 million here in Minnesota. A typical death plan from a typical estate planning attorney is going to cost a minimum of $1,500. If you are finding somebody who's charging less than $1,500, you should be suspicious about what they're doing and about what kind of care they're putting into it. And you can be almost guaranteed for that cost that it's not going to keep your family out of court or out of conflict. In fact, the attorney might be writing those estate plans in order to ensure that they have probates in the future when their practice matures, as it's called, and their clients start passing away. It's not going to ensure that your assets aren't lost to the State Department of Unclaimed Property. Again, this is not something that most estate planning attorneys cover. It's only going to cover your money. It's not going to cover your kids' immediate care, nor your values, your insights, stories, and experiences, those most valuable, intangible assets that are often the most lost assets. The alternative is working with me. I'm a personal family lawyer, and that means that I have a very personal touch. I work very closely and intimately with my clients, and we can build a plan that specifically addresses your family's needs. You can choose your own fee, likely to range somewhere between $2,000 and $8,000. And you're going to know that your plan is going to work for your family when your family needs it to work. And I can tell you, most people who come and work with me, if they want that revocable living trust that we talked about tonight, and they want to make sure that they're able to avoid probate, get incapacity planning done, make sure that they have backups and future-proof their plan as much as possible, but that revocable living trust as a linchpin of their plan, I can tell you most people are paying somewhere between $4,000 and $5,000 for that kind of planning. So I've given you very clear and very explicit information about what I'm charging for estate planning with me, and keep in mind that there are some more affordable options as well, ranging down to about $2,000 in order to work with me. And I want to make this really easy for you. I want to make it as easy as possible for you by offering you the initial meeting with me for absolutely free. And that initial meeting with me is called the Family Wealth Planning Session. It is a 2-hour-long session that we can do completely virtually. And we'll talk about things. And we'll talk about your assets, and we'll talk about the people in your family. We'll talk about what you have. I'm going to go ahead and post the link to my calendar so that you don't need to use the QR code if you don't want to, but you can just look to the chat and click there in order to schedule that meeting with me. For that family wealth planning session, again, it's a 2-hour-long session. There's some pre-work that I'll ask you to do so that we can make it as productive and have as productive a meeting as possible. But in the first hour that we meet in that meeting, that family wealth planning session, we'll talk about your family, we'll talk about your assets, we'll talk about the estate plan that you already have in place, or the estate plan that the state has written for you if you haven't done any estate planning before. And that first hour is really focused on educating and empowering you to make decisions about what you want from your estate plan. And we'll talk about how we can execute that and how we can make that happen. And then in the second hour, we actually go in and start drafting and designing that plan together. And that's where I will walk you through decisions, and you can custom tailor that plan to be exactly what you want it to be, and make sure that it works as well for your family as it possibly can. About that, so that's the second hour. And in the middle there is where you make your decision. Do you want to work with me or not? Up to that point, it is a completely complimentary meeting with me. Up to that point, there is no obligation to continue. I just want you to have the information, and I just want you to be able to ask your questions and get specific information about exactly what would currently happen in your family, what would currently happen for your assets, and how can you make a difference? How can you make a change to those in order to make sure that what you want to have happen is what's going to happen? When you book that family wealth planning session with me, that completely free, no obligation family wealth planning session, as long as you book that family wealth planning session by the end of the week, and that means by the end of the day on Saturday, I will give you $250 towards the estate planning fees or towards the estate planning package of your choice. Really happy to do that. The reason that I'm happy to give that $250 is twofold. Number one, I want to reward you for being here tonight and educating yourself on estate planning. I think that that's really important, that you're here, that you're educating yourself, that you're getting this information, and it's going to make our conversation easier and more fruitful when we meet together because you've been here and you've educated yourself. Two, I want to encourage you to take the next step. It is going to save me time and energy in following up with you if you take the next step right now and you get on my calendar. If you book that family wealth planning session by the end of the week, you will have it set. You will have your next steps absolutely crystal clear. You will be ready to move forward. You will be ready to get this done, or at least ready to have the next conversation. And I'm very happy to give you that $250 towards the plan of your choice for both of those reasons. Again, you've educated yourself. It's going to be easy to have the family wealth planning session with you. And number two, I'm not going to have to follow up with you and make you rebuild the momentum to getting your estate plan done. You will have already taken the next best step to getting your estate plan done. And that next best step is scheduling that family wealth planning session with me. So what do clients say when they come and work with me? Overwhelmingly, my clients are extremely positive about working with me. And I'm not going to read through these things because it would embarrass me to no end to read through these, but these are some of the types of things that clients say when they work with me. What I'm going to do instead is tell you a little bit more about the family wealth planning session. The family wealth planning session, as I told you, is a 2-hour-long session, and it is a virtual session. We will meet over Zoom, so you can meet from your home, you can meet from your office, wherever is most convenient for you. As long as you're in front of a computer, join me and we will talk through things together. And what will we talk about? Well, we'll talk about things like who would be the person to collect everything for you? Do you have somebody like that? Do you have a child maybe that's old enough to do that? Do you have a sibling living nearby who could help to collect everything? Is a parent still the best option for the person to step in and collect everything and make sure that everything was administered according to your trust and carried out according to your trust or brought through the probate process? And what would happen if you became incapacitated? What would that look like for you? What would that look like for your family? Is there somebody who can make healthcare decisions for you? Is there somebody who can make financial decisions for you in that case? What would probate look like for you? Is probate right for your family? And there are some people who choose probate for their family. Most do not, or their loved ones or their friends, whoever is going to receive. Most do not, but we can talk about what probate would look like for you. And we can talk about whether that's the right option or if you'd like something else to happen and how we can ensure that your family and that your loved ones don't have to go through probate. We'll talk about estate taxes. We'll talk about what you might owe in estate taxes and how we can plan for those, and how we can make sure to minimize the estate tax bill that comes due at the end of the day. And we can talk about how the people you love are going to receive your assets when you're gone. We can talk about how we can build in asset protection in order to make sure they're able to enjoy your inheritance instead of a divorcing spouse or a creditor enjoying the inheritance that you wanted them to receive. And after your family wealth planning session, I will confirm everything that we talk about in a confirmation document. And I draft your documents based on that confirmation document. And then usually what I'll do is I'll actually travel to you for the signing meeting. The key for that is that you have 2 witnesses who can come and meet with us and watch you sign your documents. And if you can't think of 2 people to come and watch you sign your documents, that's okay. I have some office space that we can meet in where we can have 2 witnesses available to watch you sign your documents. It's not a problem, but that's something kind of unique that I'm able to offer is I can travel to you for that signing meeting so that we can meet and get your documents executed in a place where you are extremely comfortable. That signing meeting is where your documents are effective. And we can get to that point in just 4 to 6 weeks after we meet for the first time, after we meet for that family wealth planning session. After that signing meeting, there is a 3rd meeting, and that's called the Family Wealth Legacy Interview Meeting. And in that meeting, we get to record some of your stories and some of your values in an interview that we will actually record for the people that you love. It's fantastic. It's something that that my clients have really loved doing, and it might sound intimidating, but I promise you it's not. It's a very gentle, very informal process, but we're also able to review things like your beneficiary designations in that meeting, or making sure that everything has been fully funded into the trust. So, next steps. Schedule your free family wealth planning session with me and take advantage and use that $250 towards your planning to get a plan in place that's going to take care of the people that you love after you're gone. You may have looked at my calendar by now. If you haven't looked at my calendar by now, I hope that you will click on that link or scan the QR code there and take a look and see what my availability is. And I'm sorry to say that I don't have any available appointments here in January. I don't believe that I have any available appointments in February, and the pickings for March are already starting to look pretty thin. But April and May, I know, are pretty open. The reason that I don't have available appointments here in January, February, and relatively few in March is that I only accept a certain number of appointments each month. And it's a select number of appointments. And the reason for that is I work very personally, very intimately with each of my clients in order to make sure that they have the attention and the care devoted to their plan that they need. It's very important, but because I have that limited number of clients, that limited number of meetings that I'm able to have, you can see that sometimes I have to push those meetings, I have to schedule those meetings out into the future. I hate to do it because I know that the best thing to do is take the next step right away and to help continue the process and help you get an estate plan in place right away. But I hope that you can appreciate that know that I'm going to be working with you very intimately, one-on-one. We're going to have a very close relationship in working through this. And I'm going to empower you to make the plan and to make the decisions that you want to make in the best educated way. So I'm going to take a look here and see if there are any questions that are coming through. I'm not really seeing anything, but now is a fantastic time. If you have a question, if you have something that's come up during the course of this webinar, or if you have something from your personal life that you want to ask about, something about an estate or something about a loved one's estate that you're curious about, or you want to have more information about, now is a really good time to bring those questions and get those answers. The family wealth planning session is also a great time to ask those questions and get those answers. But if you'd rather ask them now, if you have a question, it's likely that somebody else on the call also has the same question. And so I hope that you will go ahead and bring those questions to me. And it looks like, a few in March. April is starting to book up as well. But I hope that you'll click over and take a look at my calendar and get on the calendar so that we can have our meeting together and I can help you to take the next steps. All right, I'm not seeing any other questions, and that's just fine. No problem there. But I am going to go ahead then and call this webinar to a close. Thank you for joining me this evening. Thank you for taking the time to educate yourself on this topic. I hope that you will click through and take a look at my calendar. And I am going to send out a link to my calendar in a separate email as well with the recording information for the webinar here tonight, in case you want to review it, in case you want to access it and take a look at a portion of the meeting again. I hope that you will book an appointment with me. Again, it's a complimentary meeting. There's no obligation to continue, although most people do choose to continue. But I hope that you'll take advantage, and I hope that you'll get on my book and get some great information so that you can move forward in the best way possible. See somebody saying, thank you for the great session. Looking forward to working with you. Looking forward to working with you as well. I am excited that you've taken the next step and that you've scheduled the meeting. Looking very forward to working with anyone who is ready to take that next step and get a great plan in place for their family. So again, thank you for joining me this evening and have a great night.